Okay, should we start? Well, so if we're going with all these different metaphors and parallels, this is sort of what as an academic you start to call a dead slot. Because when everyone already networked and had all these interesting things, the closer to the end of the day, people start to leave, people start to stay outside. So it's quite tough to still keep you wide awake. So what I will try to do is I will take a certain liberty of how we go about this presentation, because what I would want to do is actually try to keep it as interactive as we can, because I think only that way you're still with me, you're not drifting away. So let's make as a starting point a deal. If at any point it starts to sound like something that is not understandable, just raise your hand. So I know that I need to stop and we need to redraft, and I will try to also narrow down the presentation that we actually haven't allocated some time for questions and answer. Okay, let's see how that goes. But the title ultimately of this presentation is very much about the legal approach towards sustainability. Right. So if first and foremost, we were focusing on understanding what this social development goals are, sustainable development, what is. So ultimately, what until now you very much have been experiencing is by our experienced colleague getting an understanding, well, what procurement is in the first place, what procurement is from a legal perspective, then also the economist perspective to it. And right now we're starting to really put the layer of the sustainability and how those all different elements work together. So what I will try to do in the next half an hour or so is, first of all, have a couple words about introductory remark, sustainable what it is actually that we're talking about, because a lot of the session that we're having right now is about concepts that are extremely fluffy. They are not very predefined elements. Pretty much, if I would ask every single one of you in this room what sustainability is to you, it can be everything and nothing. It can be different things to different people. It's very much valued-based concept. So depending what are your values, that's how you also define what sustainability is. And that in context of any research, particularly also research that's connected with law, is already problematic. Right? If you cannot really say something is in and out, yes or no, but maybe. On the other hand side, if to go with a lead of Martin, this is the type of lawyer's favorite questions, maybe, because it gives us a lot of possibility of being creative, right? And then the second point, after a couple minutes of discussing what sustainability is, the second point is, well, are those legal concepts anyhow? And why it is important to determine whether some of those are legal or not? Well, because if you go to the market, you encounter two type of stereotypical representation of contracting authority representatives, right? Public representatives. They'll be the one that will say, I want to do a lot of sustainability with my procurement, how I can do it, what I need to do. I have all these ideas, how to make it happen. And for them, you need to provide them with the limits of what is illegal and then give them opportunities what they can do. The second set of contracting authorities will be, do I really have to? Can I just ignore it? This is not relevant. I have enough work. It costs the law a lot of time. No one has time for it. And for those, we slowly, systematically over right now, I would say a good 10 years when we're discussing very effectively sustainability in public procurement, slowly starting to move, particularly also with the new Green Deal, to the space of saying, well, what is your obligation? What is the space in which you cannot anymore ignore these concepts, right? And that will be informative also for those of you who will not be necessarily working with law, because if there is an obligation, not anymore a possibility, you need to be aware of it. And then how all this then translates more specifically to public procurement. And I will use the sustainable public procurement under the European directive as an example. Now, within this session, we will not go into detail to every single provision under the directive that is pro sustainability, but we little bit draft a similar pattern of what I just described. Where there is a discretion, what are the opportunities, and when there are limits for you to ignore and for you to do something about it, right? And then the last moment I would just mention, because you will have a session more specifically on European Green Deal, but I would just mention that we potentially are in this shifting moment within this research area broadly, when we're moving from the space in which, well, it would be nice to have, and it has been sort of nudged for last 10 years saying to contracting authorities, well, it would be nice if you would do it. Could you please? It would be good for planet and people. To suddenly also at this point saying, well, we nudged you enough. It seems that you don't getting the memo. So we're going to introduce more and more obligations to force you to do so. And the question is whether this European Green Deal kind of shifts a certain space. And that's very interesting, because if you within your own research going to conclude that yes, there is that shift, then also is a very interesting space to research those obligations. So that's more or less the plan. And I will try to go through it more or less rapidly, with some references to a variety of comments that have been made today that I would like to, from my perspective, challenge a little bit and let's see how that works. I would say that the main issue, of course, is that we need to differentiate at this point between things that are valuable versus greenwashing or social washing. So actually things that are effective, right? So let's start with, well, what ultimately the sustainability what question? What are we talking about? Sustainability and sustainable development as a concept is fairly new concept. It's about 20 years roughly. So in the grand scheme of things, of legal regulation, of EU regulation, etc., international law, this is not that long time. And where we very much direct the main sort of birthplace of concepts to the very famous report by Bertland Commission called Our Common Future. And that's very much what the sustainable and sustainable development definition that was very standard, you very often will come across it, is this notion of meeting the needs of a present without compromising the ability of future generations to meet their own needs. So what that means, that ultimately means that your children and your grandchildren or your sister's children, etc., supposed to be able to benefit from the same things that we benefit today. Clean air, being able to swim in a local lake that has not been polluted and does not have gasoline in it. Hopefully not wearing mask, maybe, right, at some point, etc. So it's very much about, we are not to develop and make our life at the cost of really decreasing a quality of life of the next generation. Now, when that concept has been introduced, the concept from the very beginning was very vague. You can see just from this quote from Bertland, it's very vague. It doesn't give us a lot of sort of tangible element. Well, how we do that? That's the first question, right? And the reason for that was actually a conscious approach to this conceptual vagueness, because ultimately the idea was to rally all the countries. So everyone under such a statement can support it and rally behind it, right? It doesn't say, well, but you need to change your local economies from, let's say, coal to clean energy. You need to invest money. It doesn't say anything like that. Within the statement that is provided, everyone can sign under, right? Support it. But that at the same time became a little bit the original sin of this concept. Because systematically, as this developed over the years, the issues have been, well, but what that really means, what we actually need to do with it, how we really are to operationalize this concept in really day-to-day life, right? So ultimately, if you look from the legal standpoint, and there is a tons of research really on what sustainable development is, It is a concept, but it also constitutes, from legal perspective, a norm. It is a normative concept. What it means? Well, it means that ultimately it all prohibits something or it permits something, right? Is this sort of prescribes or permit approach to it. And over the years, we saw first references to this as a concept in a normative sense, so sort of allowing or prohibiting certain things in international law. So for those of you that are not going to be looking at specific jurisdiction countries within EU or within any actually national jurisdiction, you will probably look into international law. And those are some of the elements where you first see references to it. One of the very interesting cases is the International Court of Justice case that specifically referred to the environmental aspects of the development, that I will give you a quote in a second. But the concept became a normative element the moment that this international treaties, convention, written some reference to them within the wording of those legal acts, because those legal acts ultimately have legal consequence, legal value, not the concept in itself. So far, so good? Everyone with me so far? Good, fantastic. So up here you have an example of a quote that gives a certain value, legal value to sustainable development, but it's kept again on a very general level, right? So in this specific decision, International Court of Justice referred to specific aspects of environmental law, and points out that where development may cause significant harm to the environment, there is a duty to prevent or at least mitigate such harm, right? And if you work with legal text, you know that things like duty to prevent actually means something in legal terms. And it starts to introduce a certain obligations. The question is how far we can take it. So can we take this as an applicable already sort of binding law all the way down to, let's say, Torino municipality procurement? Well, we cannot. It's way too far. And that tends to be also the general challenge when we talk about sustainable development and when we talk about sustainable development goals, because it's kept on an extremely general level. Very often is kept in a tools or measures that are non-legally binding, the so-called soft law. Soft law means that it's a type of a good advice of a good older mentor that tells you, you know, this would be a good thing to do. But if you don't, it's not like someone will come after you. Those soft elements often are reflected also in some of the judgments as an interpretive tool. So they refer to, but they are rarely really connected with a binding effect, saying, you're not doing what you're supposed to do, we can claim damages, we can fine you, etc., etc. And I think that this is quite important. So ultimately, we find ourselves with this challenge when we look specifically on international law level. And I think that this picture really shows it quite nicely. So on the small font, it says, be sure to wash your hands and all will be well. The first smallest wave is the most immediate one, right? So the COVID-19. What will happen after we got out of COVID-19? There will be recession. And then when we go out of the recession, well, there will be climate change. If we think that we have already right now problems with floods and fires, well, let's just wait a couple of years more, right? And the issue of that is very much connected with how international law and this law of how this current global challenges is addressed under law. And there's a disconnect between the economic theory of externalities ultimately and the underlying transaction character of international law tools. What I mean by that, those international legal tools are usually, they all similarly as procurement acts and procurement directives, they have single objective. That objective, as Martin mentioned in the morning, is we need bridge needs to be delivered. That's the primarily aspect of it. In context of international law, if we're staying within broadly understood procurement, those are international trading agreements. There are liberalization of a trade globally. The main objective is how we can trade internationally in the best way. And then with time, as time went by, we realized, well, we have this problem. Environment, we have this problem of forced labor, we have this problem of child labor, and you started to add it as these externalities. And this is very much how we approach it broadly in law. So it's not anymore the aspect solely about the bridge, but it's the bridge and something on top. But what I really hope for our next 3 years, and when my hope in you is that you're not going to look at those issues from this perspective, that you're going to disturb the system, because that system doesn't work. Because as long as you have something on top, there is a limitation how far you can take it. Because you cannot ultimately disregard the underlying transactional element of those tools. So what we need to challenge, I think, and where the change needs to be done is how you redefine those underlying transactions. So this underlying transaction should be, no, it's not just about the bridge, but the bridge needs to be provided in accordance with this concept that we refer as planetary boundaries. So you cannot build the bridge and then ultimately outsource the costs to someone else because you offer a cheap price, so it's great. But because you offer a cheap price and because we don't look, because this is not, let's say, procurement issue, someone else pays the price. It's not that the price is not there. So if you outsource for the cheapest price to, let's say, predominantly countries that are from outside of EU, okay, great, you got cheap bridges, other commodities, works and services, but then you have a problem of unemployment in your own country. So yes, you save there, but now you're going to pay in social benefits. Everyone sees that? It's not, that's the reason that I get extremely upset when we're having this conversation and I hear, oh, but this increases the price. I was like, is that increasing price or the way how we've been buying for last 20 years is just something that is not sustainable? We've been paying too little. And that's the reason that there is certain element of change that needs to be underlying this disruption of how we perceive those contents. It's not something that it would be nice to have additional, but it needs to be redefined how we understand those notions. And that is also not something that in any way we try to claim within procurement specifically. Because if you look also broadly in legal literature surrounding sustainability, SDGs, CSRs, or these different concepts, it's very much prevalent similarly on private market. Example of company law. Anyone knows anything about company law? There's a concept called corporate governance, and ultimately goes to really the idea what company's objective is. And there are supportive concepts to that, such as fiduciary duties, et cetera, et cetera. And ultimately, traditionally, that area of law talks about the fact that companies, the only main objective is profit. End of story. Now, today, when you look more and more in the literature, again, from the last decade or two, there is a lot saying, no, you're a part of a broader society. The way how you work, how you interact with your workers, who you're taking care of, how you exist, you not as a company exist in a vacuum. It's contextual. You're part of a broader society. So the same way that we're challenging this concepts in a variety of different areas, we challenge them within sustainable procurement or within procurement in itself. So this issue of putting something extra on each individual area of law has been around the corner for some time, and there is a need to look at it slightly differently. Why? Because it's also the notion of, I heard some of you talking about it during break, and I was really happy about it, because one of you said, but why we need to choose? Why it needs to be, or we regulate that within procurement or tax law or state aid or something else? And I really love that comment. Why? Because exactly why. If we admit, if we are academics sitting here, and we believe in science, and science tells us that we in the climate crisis, then the approach is all hands on deck. It's not stepping around and saying, not my problem, not my area of law. Right? And I think that this is really something, yes, we won't address it fully. It will be a bit like square to the peg hole. We need to find a way. But I don't think that today it's enough to say, well, it doesn't really fit within procurement. It is very short-sighted in my personal opinion. So then when we're talking about the sustainable development and moving to the what actually the sustainable development goals are. So at some point, they've been adopted by UN in 2015 as a part of the core 2030 agenda for sustainable development. And it is a concept of 17 of those goals that are underlined by different targets. And those different targets are, again, underlined by different indicators. So this is how you ultimately will assess whether there's success in achieving the targets and then the goals. Now, have not been in any way indicated as a legal instrument or binding law. This is, again, one of those policy tools that is to rally everyone around the concept. But there is a recognition that we are different countries in global settings. Our possibilities are different. Something that can be achieved, let's say, within the budget and development of United States cannot be achieved by really small countries somewhere in the middle of the Pacific, right? So there needs to be a scalability understanding. There needs to be contextual understanding of where we are within that. So it's another example of this type of soft law. But that soft law found its way all the way through all different treaties, all different strategies. And the question is how it then translates to what we're operating with today. So how that looks more specifically, where there is a link between what you see right now and procurement. It's 12.7 more specifically, right? But it refers ultimately to the goal 12, which talks about responsible consumption and production. And then if you look specifically under the target, it goes to target 12.7, which we say, which reads, promote public procurement practices that are sustainable in accordance with national policies and priorities, right? So that kind of goes, again, you cannot do everything, but you need to do something approach. But what is interesting that when you really read through the different goals, why directly expressly there is a reference to public procurement within 12.7, procurement will be valid and relevant for majority of them. So even if it's not directly mentioned, there is a connection with how you spend public money, how you drive those economies through public procurement. But what I don't like about it is then when you look at the indicators, the only indicator in context of this is number of countries implementing sustainable public procurement policies and action plans. For me, this is a type of greenwashing. The fact that you have things in, it doesn't really mean that you achieved anything, right? Going back to the conversation, particularly also what Davida was saying and Roberto earlier, we need to start to measure and prove that we actually doing something. And that in a context of limited time, I didn't want to ask Davida about it, but one of the things that I also hope that within your empirical research, you will move forward, because I also in Denmark seen several of this research when they analyzed contract notices, so the public notices, and they look on how many times green is mentioned or sustainable is mentioned. And my point is what that gives you. You're not in any way able to assess if that goes anywhere further than greenwashing. Right? And we need to be able to actually go further and see, well, you prescribed those elements. Did you actually deliver them? Did you actually measure them? Did you actually check them? Or you just tick the box so your boss wouldn't bother you and we forgot about it? Because if that's how you're doing sustainable public procurement, then that's why our critics in the context of sustainable public procurement are fully at right of saying this is hoax, don't do it. if you think about it seriously, we need to take a step forward in that area, right? Looking on the time. Okay, so then how does SDGs, all this soft law guidelines like strategic developments, then transfer very much to the concepts of sustainable public procurement? And you heard about it already a fair bit. You for sure all reflected on the concept of sustainable public procurement just in your proposals to get this job ultimately. So this is not anyhow new. But ultimately, there is a consideration of environment and social impacts of the way how we buy stuff. And just a sideline, again, depending where you research geographically, the social consideration might be much more prevalent and human rights might be much more prevalent than an environmental one. In Europe, we definitely focused predominantly on environmental, and that's why we're being seen as a broad continent driving the green public procurement agenda. But for example, if you look on South Africa, if you look on Canada, if you look on Australia, where you have indigenous communities, when you have a societal differences of such a nature that within South African system, the promotion of Black-owned businesses is related all the way to the constitution, right? So this is all will be depending where you look ultimately. So the question right now is, you heard a little bit also about the history, how those directives went about, and you know that there is a fair bit of sustainability in the newest directive. So we're right now jumping more to European system. The questions that are still open that you may reflect within your research, whatever you'll be doing, is the question, well, did something change ultimately with those new directives? Are we still able to do the things that we were able to do beforehand? Can we truly talk about sustainability becoming a principle of public procurement? Sustainability being an objective of public procurement? Can we talk about it? There is a very interesting judgment in Tim case that reflects on Article 18.2, but is there any sort of follow-up of that? This is not really black and white. Depending if you ask Martin, myself, Roberto, and a couple of our colleagues, we probably will give you all different answers or variety of the answers of how strongly we stand by those points. And that's where the research becomes very interesting. The question that you also often need to reflect, and that's particular comment to those of you that do legal studies, is the question of competences, because we predominantly talk a lot about substance and procedural elements, but also competences. So is the EU legislator, if you look into European procurement law, actually allowed to dictate some of those elements? Do they have a competence? Because again, we're looking then on a broader EU law. There's a transfer of competences. It's not that EU can do whatever they want, right? Their power is derived from power of member states. And particularly when it comes to the environmental and human rights and social elements, there seems to be an agreement that, yes, they have a competence to reflect on that, because there are provisions on sustainable development in the treaty, so the highest legally binding acts within EU, right? But again, to really dissect what this actually means for procurement practice, that's your job. Because there is a quite far reach from this very general provisions. And the question is, well, what is the legal consequence of that provision? And then to those 2 points that I mentioned at the beginning. So you're talking to someone and the question is, well, do I have to do sustainable procurement? Or I really want to, how much I can do of it? Where are the regulations? So first, I muted myself. I think, hope now this goes. Sorry. The first question is, what are the discretions areas of sustainability when it comes to the law? And if you look at the directives right now, there's a fair bit of discretion, because you had a right to implement in your national system some of those provisions. Example of that is of a reserved contract, which relates very much to social procurement, right? And you also have extremely limited amount of very hard law obligation in the area of sustainability under the directive. The one that no one questioned is Article 69 of abnormally low tender. What that means? That means that if you got an offer that is just too good to be true, they promise you after you, they say, pay, we got you an offer, 10 euros is a milk of honey, a land of milk and honey. It should raise your eyebrows. And what the law says is you need to ask why. Because it does not necessarily means that you absolutely are, as a supplier, in violation of something. It could be that you just develop a new technology or a new innovation that really cut across all the costs so much. We've seen that over the years, right? And decades. But very often it means that you're just cutting corners somewhere. And then if you are caught to cut corners, and then there was this reference to what we sort of still a bit hesitantly refer to as sustainability principle in procurement under Article 18.2, then you're obliged to kick out such a tender from your process, right? That's one single-handedly non-questionable obligation. But the problems are there because we don't have really a definition of what abnormally low tender is, right? So it's every time that you feel like we're opening one door, we kind of get slapped on our hands from other side. Then we have the Article 18.2, and the jury is still out. By the time that we published some articles, that I published one of my articles saying it would be fantastic, I would really want, but that's not principle. The Tim judgment came out and the court said, no, it is a principle. But the court didn't say what are the legal consequences of that. The court didn't say we're going to go after all the countries that are not actually executing this, right? So this one is still quite problematic, I would say. So then what are your limitations? And the first is the limitation, if you really don't want to do sustainability, what is your limitation? And that limitation ultimately will often follow from different sources of law. So this is also for those of you who will look in particular sectors, something that you need to be aware of, that looking just into what is the general procurement regulation may not be enough. Because if you look into transport, for example, there is a directive on clean vehicles, right? That mandates you actually being environmentally friendly in the way how you procure the cars. And then you have a list of several of others, and there is a variety predominantly of environmental issues, because again, that's what we mainly focusing within EU. But there is also one, for example, on accessibility that has of a more social element. Another thing is that if you will be looking in case studies or in particular countries, if that is Mexico, Netherlands, Italy, etc., there might be sources of obligation that follow from national law. And we have, Martin was talking to you about these different levels, right, for thresholds, etc., etc. Different national systems also will have a regulatory obligation. So for example, in context of Denmark, if procurement is done by central government, there is an obligation of having labor-related clauses within the procurement contracts. So that you need to secure your labor force, particularly on construction contract. It specifically refers to construction contracts, right? And other countries will have quite obligatory approach to green criteria in general, and they usually will be in context of targets established, that you need to reach certain targets, right? So it is a bit of maze of different things. And the reason of that, why I bring that up, because you may on the first read say, fine, procurement law, the main general, not really obligation much. But then those will get you in a different space. And then on other way, if we try to flip it out and say, well, I really want to. I really, really want to be the most sustainable city council or country in EU. It's really good for policies and governments, and our electorate, for example, in Scandinavian countries, really like us to be green. Can we be as green as we can? And then up here, the limits that are applicable is mainly the before mentioned link to the subject matter, right? You need to be aware of that. There is a reference to this Article 18.2 of the applicable laws. You need to be aware. Has a bit of a mandatory element and what possibilities this creates for you. And then this also proportionality, again, and the appropriate measures to define the characteristics of ultimately what you're buying. And then from that conversation to my last comment on this shift, potential shift. Everyone heard about this Green Deal, European Green Deal? Hands up. Anyone? Okay, some of you, some maybe not necessarily. Okay, so when we're thinking about European Green Deal, I think that very loosely we could actually compare it to something as the SDGs, just on European level. So it's a strategy that has been presented about the future of the EU. It's a general strategy that cuts across variety of different sectors, policies, etc., etc. The goal is one and clear: to make Europe a climate neutral continent by 2050 and to drop the emissions by 55%. And then that translates obviously on a variety of questions. Well, who will pay for it? How are we going to do it? What's going to happen? Etc., etc. And then on that basis, the Commission published different action plans and funding plans in which they roll out a different indication how this goal is to be achieved. And why this is interesting in context of procurement. Because on the one hand side, within the Green Deal Commission acknowledged that the green public procurement did not achieve yet the hopes that have been placed in green public procurement. There's been a lot of guidelines. It's not well written, but it's a little bit, if I would want to tell you a story and I kind of imagine being the fly on the wall, it's almost like they say, well, we tried to nudge them for 10 years. We asked, we pleaded. They said, we don't have criteria. We created all these different criteria for different sectors. We provided them with good practices. We given them guidelines. We give them money to invest in professionalization of the procurement teams. And those that have been doing that, they continue to doing that. And those that refuse to touch it from different valid reasons still don't do that. So it almost seems like they said, okay, it's about time that we're going to force them now. And that's a little bit what if you look more specifically within the investment plan, that is the next document that was then published after the strategy, the investment plan, which ultimately says that in context of public procurement, there will be a proposal of minimum mandatory green criteria and targets. And they also pointing out that in specific sectors, so those minimum criteria, they will not be included within the directive, the General Procurement Directive, but in specific sectors. And there are pretty much all the ESRs that you look and the topical interest that you have within your ESRs, I would say that there is something within those new strategies on there. There's a policy of from farm to fork that will provide the minimum mandatory requirements in food. There is one on transport. There is one on energy. There is one on construction. So this is very interesting because there will be a lot of new developments that will be hopefully helpful and sort of feeding your projects. So that's pretty much from me when it comes to what I wanted to tell you. What I would want you to take away from it is, on the one hand side, to have an understanding that majority within sustainability area is guidelines, soft law, strategies, things that are not binding you. So things that if you don't do them, it's not like someone can sue you. It's not like, let's say, Martin is having a tender and Natasha submitted a bid and Federica won the bid, and Natasha is very upset because it's area of, let's say, standards or area that is very well developed in environmental context. But Martin didn't ask about anything environmental within this tender. So we saw that on national level in Denmark and other countries that bidders would come, but my offer was the same when it comes to, let's say, financial value and offer, but mine was much greener. Why I didn't win? And that is ultimately to the fact that it's still left to the discretion of the buyer to define what they want to buy. And because there is no an obligation majority of time, you cannot get upset and sue them for the fact that they are not sustainable, right? So those would be the main takeaways. And there is this seismic change a little bit right now with Green Deal when we move into more obligation. We have about 5 minutes. Somehow I managed to achieve that. So any questions or any comments that you have to that? Yes. We like those. Mm-hmm. So this is a bit charged question, and we could have another hour about it. And I will tell you why. Because I think that we need to again remember the context, right? Yes, it's very easy to say internal market is all about this. No, it's not. Why internal market was established at the very beginning? Peace, right? If you really want to go all the way back history, it's nothing to do with competition as such, indirectly, because the idea was if we intertwine our businesses, we'll be less prevalent to kind of try to go to war with each other, right? And then over the years, also the issue is that the main challenge that we have with European law is that this area of trade, commercial dealing, internal market developed separately, and the other parallel development of a social laws developed separately, and they don't talk to each other. But very often, then, when you look actually at the European Court of Justice decision, the court is very hesitant to say competition is more important than human rights, right? You won't find a judgment like that. They try to do everything that they can to just not value between those, because those are not things that you kind of pick against each other. And then another aspect of it is that you need to again look at it historically, right? Around the time when there was the idea of European Constitution, which didn't won enough of referendum electorate, a lot of the provisions from this draft of the European Constitution ended up ultimately within the Lisbon Treaty, right? So the newest treaty. And since then, we also talk about this switch towards social welfare market economy, right? And what that means, and we do in many ways, again, if you look at an integration, we look, this is not the type of, we are not a construct as free trading agreements outside of EU. This is a concept that is much more intertwined. But I think that this also, and I had some conversations with you over lunch, that I think that this will also, what I'm saying right now is not honest given truth, because this is my opinion, and that comes from my normative standpoint. And that is connected with the values and how I read EU law. If you have, let's say, competition law professor sitting next to me, he probably would disagree. I'm not also quite sure whether Martin, to certain things that I'm saying right now, would not disagree. So this is, the normative standpoint also is very important, because you argue and you use the research and the judgments and so on and so forth. There's enough to support this, but there is equally enough to challenge this, if that makes sense. Yeah. Mm-hmm. I think that this is brilliant element that you noticed, because also when we talk about sustainable development, if we go back to the beginning of my presentation, this is also very much charged depending again where in the world you are. Because what sustainable development means for Western world and what sustainable development means for African country, right? In many ways. And then it's also a question of capacities. In a way, I think it also is a notion of capacities. But I think if you look at free trade agreements, where I think there is also an issue is how to ensure that we don't do this thing that we started to do until now, if that is with GPA or with the first mentioning of sustainable development within the directives, which is we mention something, but we don't go all the way in. And when you don't go all the way in, when you don't tie with effects, with breaches, with consequences, those provisions, it becomes sort of something that does not fit. And we very much see that currently with the directives, right? With the EU directives, because it's very difficult to challenge the notion that this is just something additional, right? It's almost like you need to redraft, reconstruct. That's the reason that I'm saying disturb the system. Go back to say, well, this is not something additional. How we define quality, right? We keep on talking value for money is God-given thing. It's certain, it's economical. No, it's not. If you actually go and start reading on what value for money is where you put the value. And the concept in itself is not very predefined specific concept. In many ways, it is actually similar to sustainability. It's quite fluffy. And I think that within that already, if it is about efficiency, if it is about quality, how you define that? Can you define quality without outside these notions of, social and environmental elements, right? For example, just along the way. So that's I think that this is the challenge that you will have, because, it's one thing to say, yeah, it will be fantastic. In our trade agreements, we'll just add sustainability is important. But when push comes to shove, and the open trade still prevails, did we move anywhere? We didn't, right? So I think that element is there. Let me just have a look. I'm running slightly over the time, but I'm here till the end of the week. I like to talk. I will talk with all of you. So we will have more chats. I don't want to eat out of the time of the next speaker. So thank you so much for bearing with me and for the question. And I'm looking forward to chatting with you some more. Yes, I will answer them right now. Yeah. I will.
Last session for today.